Hello, and welcome to this webinar called How to Make an Administration Appointment under the Insolvency, England and Wales 2016 rules. During this webinar, I will refer to those rules as the Insolvency rules or simply as the new rules. My name is Stefan Ramel and I am a barrister at Guildhall Chambers. I practice in insolvency and in commercial law. Let me start as regards administrations with some basics. The rules come into force on the 6th of April 2017 and they represent the most substantial change to the procedure which governs insolvency proceedings for a long time. They make a number of significant changes to all manner of insolvency proceedings. So far as administration provisions are concerned, they are now in Part 3 of the new rules. Now, it's probably fair to say, by way of an overall comment, that the provisions as regards the appointment of administrators are not completely revolutionised or altered by the implementation of the new rules. There are, however, some changes. If I had to pick the most substantial change, it would be the fact that whereas under the old rules there were prescribed forms to be used to appoint administrators and to make applications to court for the appointment of administrators, those forms are abolished under the new rules. In the week before the new rules come into force, the court service has decided to create some new forms. Now, they are not yet available as at the time of recording this webinar. There is one such form which will be relevant in the case of administrations, and it is a form called COMP, C-O-M-P 8, COMP 8, and that is an administration application. There is at the moment no proposed standard form for administration orders. Now, the new rules, as the old ones had to, provide for administration appointments by way of court application, administration appointments by a qualifying floating charge holder, and finally administration appointments by the company or the director out of court. And I propose to look at each of those three categories in turn, starting with the rules which govern the court process. They are contained in a new Chapter 2. The application itself must be filed in court along with a witness statement and a consent to act by the administrators. That is fixed by Rule 3.7. When the application is filed, the court will apply a seal and fix a venue and time for the hearing of the application. The sealed copy of the application falls then to be served by the applicant. Now, by paragraph 12, subparagraph 2 of Schedule B1, it is to be served on any administrative receiver, on any person entitled to appoint an administrative receiver, and on any person entitled to appoint an administrator under paragraph 14 of Schedule B1. Now, by Rule 3.8, Subrule 3, it is also to be served on the petitioner in a winding up petition if there is one, and or on a provisional liquidator, again, if there is one. If there is a member state liquidator, it must also be served on that person, and finally, of course, on the company, to the extent that the application is not made by the company, but by some other person. If there is a CVA in force, then it has to be served on the supervisor and, of course, on the administrator. The new rules contain a number of provisions which govern service, although they are not to be found in Part 3. Instead, they are to be found in Schedule 4 of the new rules, and in particular, paragraph 3 of that schedule. That provides that the company must be served at its registered office and any other person can be served at their proper address. Their proper address is an address given for service, or if no such address is given, then it can be served on the person's usual or last known residence. Schedule 4 to the rules also contains a table showing which documents are treated as claim forms and which are other documents, having in mind CPR Part 6, which is the part of CPR which deals with service. An application for an administration order is treated as a claim form, as are notices of intention to appoint. so beware of the service rules which apply to them. Now, once service of the application has been effected, a certificate of service must be filed as soon as reasonably practicable after service, but in any event not later than 2 business days before the date of the hearing. Now, to the extent that there are any enforcement proceedings ongoing in respect to the company, notice must also be given to the enforcement agents, and if the applicant becomes aware of any cross-border insolvency proceedings in another jurisdiction in respect to the company, they must also serve on those persons. So far as the hearing itself is concerned, the list of attendees, or at least permitted attendees, is similar to what it was under the old rules. They include the applicant, of course, the company, the proposed administrators, the directors, and any administrative receiver which is appointed, and so on. There is also, as regards the costs of the application, note Rule 3.12, Subrule 2, and that provides that if the court makes an administration order, the costs of the application and of any other person who has appeared and who has been allowed are to be treated as expenses of the administration. As I've already alluded to, the order is now no longer contained in a form, although as with other parts of this part of Part 3, Rule 3.13 contains information which is prescribed. The same is true as regards the application and the witness statement. So in a departure and change from the old rules, the list of contents of those statements and documents is more prescriptive than one would expect under the old rules, probably to do with the fact that the old forms have been abolished. Let me now leave the in-court process governed by Chapter 2 and instead look at the first of the 2 out-of-court processes that I've highlighted. And that is the out-of-court appointment by qualifying floating charge holder. That's governed by Chapter 3 of Part 3. And of course, because paragraph 15.1 of Schedule B1 hasn't changed, the same 2-stage process is still catered for in the rules. That is a notice of intention to appoint administrators and then a notice of appointment of administrators are the 2 documents. Of course, there is a difference with the old rules insofar as there are no prescribed forms for that. The rules do set out what each of the 2 documents must contain. So far as the notice of intention to appoint administrators is concerned, those requirements you will find in Rule 3.16, Subrule 2. And so far as the notice of appointment itself is concerned, one must look to Rule 3.17, Subrule 1. Now, when filing the notices of appointment, the qualifying floating charge holder must file 3 notices of appointment with the court, the consent to act, and the evidence in support, as well as evidence that notice of intention was given as appropriate and copies of any consents. That is all catered for in Rule 3.18. Let me make one other observation as regards filing. As from the 25th of April 2017, if the filing is going to take place in the Companies or Bankruptcy Court in London at the Rolls Building, the new e-filing procedure will be in effect and mandatory, so beware of that. When the court receives the documents, it has to apply the court seal to them, give copies for service, and endorse a time and date on the notices. Now, there are also rules for making out-of-court appointments, as there were under the old rules, when the court office is closed. And those rules are contained in Rule 3.20 and 3.21. As was the position under the old rules, it is possible for a qualifying floating charge holder to fax or email their notice to the court. If that is done, the qualifying floating charge holder must retain a hard copy of the fax or the email, and the fax number and email address are to be published by the Secretary of State. Now, there's a requirement that, and I quote directly from the new rules, on the next occasion that the court is open for business, the qualifying floating charge holder must take to the court 3 copies of the faxed or emailed notice, as well as the other documents I've already alluded to, and a statement of the reason why the appointment was made when the court office was closed. Now, the legal effect of an appointment where the court office is closed is the same as when it's made during court hours. That's fixed by Rule 3.22. It takes effect from the date and time of the fax transmission or the sending of the email. Now there is a caveat, and it's contained in Rule 3.20, Subrule 9, and that is the rule which requires the filing of the documents on the next occasion that the court is open. If those requirements are not met, the appointment ceases to have effect. Let me turn finally to the third of the types of appointments that I've alluded to. It is appointment out of court by the company or the directors. The rules for that are now contained in Chapter 4, and of course, as was the condition under the old rules, as a result of paragraph 25 of Schedule B1, this power doesn't arise if there is an outstanding application to appoint administrators, or an administrative receiver has been appointed, or a winding up petition is extant. As with the position that I've just described in respect of a qualifying floating charge holder appointment, there is a two-stage process. First of all, a notice of intention to appoint. Secondly, a notice of appointment. The contents of those notices are, of course, prescribed by the rules, and practitioners will find that in Rule 3.23. Note, as was the position under the old rules, it is still required that the notice is accompanied by a copy of the resolution of the company appointing the directors, or if the resolution appointing the administrators, or if the resolution is by the directors, a record of the decision of the directors to make the appointment. The details of the notice of appointment itself are now contained in Rule 3.24. The details for the notice of intention to appoint the notice of intention to appoint are in Rule 3.25. Thank you very much for listening. That concludes this update on the new rules for the appointment of administrators.